Welcome everyone to our webinar on sexual harassment and bullying in the workplace. I hope you are all having a great morning. My name is Ruby Mills and I am an associate in LegalVision's employment team. I'm joined today by my colleague Louise Miao, who is also an associate in our team. So before we begin, a couple of quick housekeeping items. You will be emailed the recording and the slides of this webinar, so don't feel like you need to be furiously writing notes. You can also submit any questions you have in the chat box and we'll try to get to them at the end of the presentation. We would also really appreciate if you could complete the survey that pops up after the webinar. We really do appreciate your feedback. So all attendees are also eligible to receive a free consultation with us to discuss how we can help you with any of your legal needs. To request your free consultation, just provide us with your contact details in the survey that appears at the end of the webinar. So today we will be providing you with a bit of an overview of sexual harassment and bullying in the workplace and discussing your obligations as an employer. We will then outline some new legislation passed recently in relation to sexual harassment, and finally, we will give you some practical tips for dealing with and preventing sexual harassment and bullying from occurring in your workplace. Louise will now kick us off by giving an overview of what constitutes sexual harassment and bullying in the workplace.
Thanks very much, Ruby, and welcome everyone. To start off with, let's go through what sexual harassment and bullying in the workplace is. So workplace bullying is generally any repeated behaviour that is unreasonable, which can also affect and harm an employees physically and psychologically. The key to identifying workplace bullying is that the behaviour must be repeated and it must also be unreasonable in the circumstance. So workplace bullying can include harassment, discrimination, or violence. Generally, any one-off act is not considered workplace bullying, although this is still usually serious and should not be ignored. Workplace bullying, harassment, and discrimination is important to identify because it can lead to a depreciation in staff morale. It can lead to stress and impact on employees' health. It can increase staff turnover. It can damage the employee and employer's relationships, and it can impact on productivity and the profit of the business. And it may also lead to an employee taking action against the employer. And this obviously results in financial payout, but can also damage the organization's reputation, as well as the reputation of the person whose behavior is in question. Although it's obvious to say that bullying and harassment in the workplace should not occur, in New Zealand, 2 in 5 workers reported to believing that they've been subjected to workplace bullying in their lifetime. Workplace bullying may happen between senior and junior staff, employees, or even between contractors, customers, or clients. Sexual harassment in the workplace is often unreported as it can be uncomfortable to talk about. Sexual harassment is defined in the Act as direct or indirect requests for sexual activity. So this means it can include written or spoken information of sexual nature, visual material, or obviously physical behavior of a sexual nature. So this means it can include anything from unwelcome sexual advances or requests for any favors or conduct of a sexual nature, which create a hostile work environment. And it often occurs where there's a promise for better treatment in the workplace or a threat for worse treatment. One of the leading cases on sexual harassment is Kumar and Icehouse New Zealand Limited. And this is a case where the alleged actions of an employee weren't actually sexual in nature. It involved standing close to and occasionally brushing up and bumping into another employee. However, the courts found, because the actions were repetitive and the specific circumstance that the acts were occurring in, that it met the threshold for sexual harassment. It is important to understand that any actions or words with a sexual connotation which can affect an employee and their ability to work can be considered sexual harassment, especially where it is repetitive and it creates an uncomfortable atmosphere. Sexual harassment is a health and safety risk to the workplace, and employers have a responsibility under employment and health and safety laws, as well as under the Human Rights Act. So now I'll hand back over to Ruby to talk more in depth about your employer obligations.
Thank you for that, Louise. So in order to ensure that employers are aware of and managing sexual harassment and bullying in the workplace, there are some practical ways that you can check in with employees to make sure that bullying isn't occurring and make sure that if it is, that you are aware of it. And this can be by conducting regular worker surveys, having focus groups and conducting regular appraisals, making sure feedback is received, particularly in exit interviews, taking note of any repeated absenteeism or sick leave, and making employee assistance programs available to staff, as well as just keeping an eye on resignations and any regular turnover. It is important that employers have clear processes in place when it comes to dealing with harassment and bullying, and it is important that these processes are followed and carried out if any issues are raised. So in order to ensure that processes are followed, we recommend that employers take all allegations seriously from the outset, that employers act promptly if any issues are raised. So this can be by setting timelines and dealing with reports or complaints as soon as you receive them. Clearly communicating the process to all employees. So this can be by telling everyone involved what the process is and letting the people know that are involved if there are any delays to those proposed timelines. Ensuring non-victimisation in the process. So this aims to protect the people involved from any victimisation. Offering support to the people involved. So anyone involved should be told that they can have a support person present at interviews or meetings, for example, a health and safety representative, their union, if it's applicable, a colleague or a friend. And telling everyone involved what support is available to them. So if you do have an employee assistance program or any health and safety representatives in your business. Of course, maintaining privacy and confidentiality is very important. Ensuring the details of the matter are only known to those directly concerned, other than their representative or their support person. And lastly, always remaining unbiased and fair. So treating the people involved fairly, involving someone unbiased and trained to look into allegations, making decisions on how to deal with the allegation based on the facts, and clearly telling those people involved what you are going to do to address the allegation, of course taking into account their privacy. So as expected, it is the employer's responsibility to make sure that they are setting the example of what is acceptable in the workplace and ensure the health and safety of workers in the workplace as far as is reasonably practicable. So in terms of employees, they must take their own reasonable care of their own health and safety and make sure that their acts or omissions don't have a negative impact on other people's health and safety. In terms of employers' obligations surrounding culture, work environments should be free from intimidation and inappropriate behaviour. And it is the employer's responsibility to take steps so that employees are safe and free from bullying, harassment and discrimination at work. So building a positive workplace culture and promoting respect is an important part of this. Complaints of bullying, harassment and discrimination should be investigated straight away by the employer, and the person who has been subjected to the behaviour should be supported appropriately by the organisation. If the employer doesn't deal quickly with complaints, and if, for example, an inappropriate joke is made and they just decided to let it go, this culture can become what's seen as normal, and it can become very hard to change in the future. Workplace policies should set behaviour expectations in the workplace. However, if managers are seen to tolerate inappropriate behaviour from staff or customers, then this culture may mean staff don't feel comfortable raising issues even if there is a policy in place. So in terms of obligations, again, employers should lead by example to demonstrate the desired culture of their workplace to their staff by creating an environment where employees know what appropriate behaviour looks like and what treating others with respect looks like. Providing training and information for managers is quite helpful here, so that there are enough people trained to deal sensibly and appropriately with any complaints if they do arise. And if you are a small organisation, this can be costly, so you could look to join with other employers who work in the area of an employers association to carry out training for a reduced cost, or you could also do the same with developing your policy and processes. So in terms of policies, another key consideration for employers is of course, we recommend having workplace policies against bullying, harassment and discrimination in place, and in these policies having defined processes to try to resolve with these issues internally. The policies usually include definitions of each of the categories and give clear guidance to employers and employees as to what behaviour is not acceptable in the workplace. These policies also should clarify the rights and obligations of both employees and managers, and these clear definitions may help to protect employees from overly sensitive employees. So a policy on bullying, discrimination or harassment should ideally include a clear statement that bullying, discrimination or harassment is never acceptable at any level of the organisation, and that all staff are expected to show respect to each other, be actively supported by the senior managers of the organisation, so including modelling respectful behaviours themselves at work, having a reporting process that is clear and makes it easy for employees to get help. Consulting with employees, we find, on the policy and process will help to make sure that this complaint process is appropriate for your workplace. Providing support for employees who make a complaint, and making sure that each complaint is investigated sensitively, objectively, and in a timely manner. And also making sure, again, that the confidentiality and privacy is maintained for all the parties that are involved in a complaint. If, of course, however, a complaint is raised and no policy is in place, there is a recent case on this issue which was held in the Employment Court, where the court referred to a WorkSafe guide called Preventing and Responding to Workplace Bullying. And it was noted that where a workplace did not have a bullying or harassment policy in place, that this would be the guiding document. So this just highlights that it is important for employers to have a policy, otherwise a court may look for an external guideline to help assess the employer's obligations. However, in saying all of this, despite an employer following its obligations and having policies in place to manage bullying and harassment, a complaint may still happen. Louise will now discuss how to manage complaints for bullying and harassment in the workplace.
Thanks very much, Ruby. So in terms of managing complaints, there are two aspects that you need to consider when dealing with bullying and harassment, and this should be done together. So the first is the person that has raised the complaint or the person who's being subject to the harassment or bullying, and the other aspect is the person who the complaint is about. So if you do receive a complaint of bullying or harassment, you will need to ensure that this investigation is done properly on both sides. If it's not done properly, both the complainant or the person being complained about can bring actions against your business. It's also important to remember that the complaint isn't always made by the complainant. It can also be by another employee or someone who's just seen the behaviour take place. Even if the person who has suffered the harassment or bullying doesn't want to make a fuss about the situation, it should always be investigated because it can still be considered misconduct. And obviously this goes without saying, but in addition to the investigation, if there is a serious case of bullying or harassment, this should be referred to the police if any of it amounts to a criminal offence. Due to the sensitive nature of the allegations, employers do need to ensure that the investigation is kept confidential. Where the complainant and the person being complained about work within the same team or very closely with each other, it is appropriate to separate them while the investigation is ongoing. It might be a temporary relocation, like a desk change, or even asking an employee whether they prefer to work from home. Ensure that this is done in a way which doesn't make it seem as though it's a punishment. If the allegation is extremely serious, you may want to consider suspension as well. Once the investigation takes place and you have determined that bullying or harassment has not taken place, it is still recommended that you remind staff what kind of behaviour is considered acceptable in the workplace. On the other hand, if you determine that bullying and harassment has taken place, then you may need to take disciplinary action against the person being complained about. This could include a warning or a permanent relocation to another area of the workplace, or if it's a serious situation, it can lead to dismissal. You should always ensure that you continue to support the complainant. This might be directing them to external support or discussing with them how you as an employer can support them. You should also ensure that you have the proper workplace policies that address bullying and harassment in the workplace in place. It is possible that your employee will not be happy with the outcome, and in these situations, they have 3 avenues to address this. The first being mediation to try seek compensation, and the second would be to bring an action with the Human Rights Review Tribunal, which would only be available for discrimination or harassment. And lastly, the most common is to be raising a personal grievance, and there are time limits on bringing these actions, which we will be discussing later. Now I'll pass back to Ruby to talk about some practical examples of sexual harassment and bullying in the workplace.
Thanks, Louise. So as Louise has just mentioned, in terms of how employees can raise a personal grievance, they can do this for sexual harassment or bullying in the Employment Relations Authority, otherwise known as the ERA, or in the Human Rights Review Tribunal. So the ERA recently released a decision shedding some much needed light on their approach when it comes to cases of sexual harassment. So the decision is also useful for employers in determining how to deal with a complaint of sexual harassment. So in this case, the employee complained that she had been subject to sexual harassment from her assistant manager. The employer investigated the employee's complaint and had an independent person review this investigation. The employee was unhappy with the outcome of the investigation, and after various discussions with the employer, including about returning to work, she felt she had no choice but to resign. The employee then raised a personal grievance for sexual harassment and unjustified dismissal. The ERA determined that the following questions are relevant to assessing the employee's claim for sexual harassment. These were, did the employee raise a complaint of sexual harassment? If so, did the employer investigate the complaint? Had the employee been sexually harassed? i.e., was the employer satisfied that the employee's complaint had substance? Was the employee then subjected to further sexual harassment? If so, had the employer failed to take steps to prevent the further sexual harassment from occurring? So just important to note, this test applies specifically to harassment suffered from a co-employee, client, or customer of the employer. The test does differ when it comes to sexual harassment from an employee's employer or a representative of that employer. We recommend seeking legal advice if you do have any questions around that specific test. So in this case, the ERA ultimately found that the person who brought the case for sexual harassment's claim failed. However, the employee's claim for unjustified dismissal succeeded, and the court found the employer had breached its obligation to provide a safe work environment by failing to intervene during inappropriate conversations and remind employees of the company's expectations. So, although generic policies and training were provided in relation to sexual harassment, the court found no action was taken in the face of actual unwanted and offensive sexual behaviour. So the employee in this case was awarded $30,000 as compensation for hurt and humiliation. So taking active steps to prevent sexual harassment and bullying and ensuring that policies are in place will help employers to avoid costly litigation, maintain a healthy workplace culture, and remain having a great reputation. So Louise will now discuss the changes to the legislation around time to raise personal grievance for sexual harassment and what this means for employers.
Thanks, Ruby. So from the 13th of June 2023, employees will have 12 months to raise a personal grievance related to sexual harassment. So this is increased from the general 90 days for personal grievances to align with the 12-month period under the Human Rights Review Tribunal. Obviously, this goes without saying, but coming forward to report sexual harassment is difficult, and many people wait a long time before coming forward, if they come forward at all. So the purpose of the extension of time is to allow for victims to consider the situation before deciding whether they would like to raise a personal grievance. So what the change in the law has actually done is that it's extended the time frame for employees to raise the personal grievance with their employer or a controlling third party if it's a triangular employment relationship for sexual harassment from 90 days to 12 months. So this extended time frame starts from the date that the sexual harassment in the workplace occurred or when it came into the employee's notice, whichever is later. The new time applies to sexual harassment events that happened or came into the notice after the 13th of June 2023 and applies even if the employee leaves the place of employment within the 12-month period. So the time frame to raise a personal grievance for any other personal grievance is still 90 days, starting on the date that the alleged action took place or came to the notice of the employee, whichever is later. And just to clarify the meaning of came to the notice of the employee, it's just because sometimes harassment can occur without the employee knowing. For example, if colleagues are making comments behind a particular employee's back without their knowledge. And because of these changes, there are a few amendments you may need to make as an employer to your employment documents. So firstly, by law, your employment agreements should already contain a clause on how to resolve employment relationship problems, including the amount of time it takes to raise a personal grievance. In addition to this, you will now need to ensure that the modified time to raise a personal grievance for sexual harassment has been included. You do not need to update any existing employment agreements as with employees and employers, they're already covered by the modified time by law, regardless of what the agreement states. However, under your good faith obligations as an employer, they should be discussed and brought to the attention the next time the agreements are reviewed or updated with employees. And as a general note, any changes to the agreements do need to be agreed to in writing by both parties. Employers should also review their company policies, specifically those relating to resolving employment relationship problems and harassment and bullying. If these policies refer to the specific time periods or process for raising a personal grievance, they should be updated to reflect the extended time frame. On a practical note, the law does not apply retrospectively, and this means if an employee has experienced sexual harassment and this has come to the employer's attention before the 13th of June, then the employer will only have 90 days to raise this personal grievance. The most important implication for employers is that all employment agreements entered into from the 13th of June 2023 must include the reference to the extended time frame. And we recommend checking that all templated employment agreements reflect this change. Employers are not obligated to notify current employees about this change in law. However, as a matter of best practice, we recommend informing all current employees of this change in writing, and this might be in the form of a letter or by email, or as a general communication about any necessary updates to your current company policies. A failure to update employment agreements entered into from the 13th of June could give rise to a potential penalty of up to $20,000 and allow employees to take legal action if they haven't raised the personal grievance for sexual harassment within the 12 months. So that concludes the main part of our webinar. You may find our publication, the How to Hire and Inspire Guide, useful. You can download this via the handout section in the webinar panel, or you can use the QR code on screen. We also have an upcoming webinar that may be of interest to you, Disputes 101, How to Prevent and Manage Commercial Contract Disputes, on the 19th of September at 12 p.m. And you can register at the link on the screen. We're going to answer some of your questions shortly, and while you submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. And for affordable monthly fee, you can receive cost certainty and an all-inclusive legal service, including unlimited document review, such as drafting, amending, and reviewing business contracts and commercial leases. It includes unlimited advice consultations with our teams, including business structuring, employment disputes, and more. And it also includes unlimited domestic trademark registration. As a LegalVision member, you won't have to worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing any additional legal work. If you are an existing member, you can now add on our work health and safety advisory service, which helps you comply with your legal obligations under health and safety law. To learn more about how membership can help you, request a free consultation when the survey appears at the end of the webinar. And now we'll get to answering some of your questions. Just to note that we might not be able to answer some questions which are too complex, but are happy to do so in our free consultation. So the first question that we have is, what proactive and practical steps can employers take to prevent sexual harassment from happening? And how do we encourage staff to speak up if it does happen?
So as we've touched on, building a strong workplace culture is very important, and making sure it's clear that it's not tolerated, and ensuring that senior managers lead by example can be very helpful to preventing it. And if any complaints are made, of course, investigating them and addressing the issues as soon as you can. Again, having policies and proper complaints process is important, as we've touched on, so employees can refer to a step-by-step guide if they do need to make a complaint. And another alternative is to have an anonymous hotline. This can be by email or phone, and this can be to report any incidents or any experiences that employees have. And the real key is to ensure that this, of course, remains anonymous as possible if the victim doesn't want to come forward immediately.
Yeah. So what happens if an employee makes a malicious complaint for bullying or harassment?
So if after an investigation into the complaint, it is decided that the complaint was made maliciously, and it's found that the bullying or the harassment or discrimination didn't happen, a misconduct investigation could be held in relation to that person who made the complaint. So that's a separate process.
Next question we have is, are there any specific resources or support networks available for individuals who have been affected by workplace harassment or bullying?
Yep, EAP counselling is a really good option. And this can be offered to employees and make sure that they're aware that it's available if you do sign up to it. You may also want to consider a peer support program. And there is a victim support. This can be offered to employees, but it is an agency that helps victims of crime and trauma, and they are available 24/7. So it's just making sure your employees are aware if there are those support networks available that they can access confidentially.
Are there any industry-specific guidelines or regulations in New Zealand that companies should be aware of when dealing with sexual harassment and bullying?
So if you don't have your own anti-discrimination, bullying and harassment policy in place, then we highly recommend putting this in place in the first instance. And of course, we can help there if you need it. Otherwise, you can also refer to the Preventing and Responding to Workplace Bullying guidelines. So if any disputes do arise and they go to court and you don't have a policy in place, as we touched on in our webinar, the courts will refer to this in lieu of your company having a policy.
So can you provide some examples of best practices that organisations have implemented to prevent sexual harassment and bullying in the workplace?
Yep, so having strong policies in place, as we've set out, and a clear understanding around what is and what isn't acceptable behaviour. Again, investigating complaints quickly and thoroughly is really important, and keeping an eye on staff behaviour, regular turnover, unexplained absenteeism is important too.
And what can employees do if they feel that their complaints about harassment are not being taken seriously by their employer?
I think the best thing to do there would be to raise it with somebody that they feel comfortable with in the workplace. If not, then they can seek external help, either speak to a counsellor or raise it with another representative.
And how can organisations ensure that their policies and procedures regarding harassment and bullying are effectively communicated to all employees?
So when having the policy communicated when it's introduced is important. So this could be at a staff meeting or by email, if it's a company-wide email, communicating it to all employees, and then letting the employees know where the policy is kept is important, and making sure they are informed that those policies are in place told to read them, and of course know where to access them after they've read them. This could be in a folder or on a wall somewhere, and it's also important that if issues are raised, that the employee is reminded of the policy for guidance.
And what are some warning signs that indicate a workplace may have toxic culture that perpetuates harassment and bullying?
Again, possibly regular staff turnover, regular complaints or fear of making a complaint, confusion or avoidance by employees possibly, if there's regular workplace gossip or just an overall low employee morale, may be signs that there's a bit of a toxic culture going on.
And what about events that happen outside of work hours or social events? Is an employer still responsible in that situation?
Yeah, so having outside events is quite common. These can be Christmas functions and things like that. Again, we recommend that, yes, your obligations still apply. So if there are complaints that arise, then they still need to be treated seriously, as they would do if they were in the workplace.
And if we didn't answer your question today, please book in a consult and we're happy to discuss further. Otherwise, that is all the time we have for today. And after the webinar ends, a survey will pop up. We would really appreciate it if you could complete the 30-second survey, and please include your contact details to receive a complimentary legal consultation to discuss how we might be able to help you with any questions around bullying and harassment in the workplace.
Thank you.
Thank you.